Your bond is $20,000 on each case, two cases, they're doubled to $40,000 on each case. The bond to revoke, they're doubled. Plus, you must have a drug patch at all times. You're charged with unlawful possession of a firearm by a felon. But all the priors, this is showing that you are an habitual felon, which means you're looking at a minimum of 25 years in prison to life. You were a habitual felon 2 convictions ago, since 2018. So here we are. Yes. Announcement.
We can get about 4 weeks from now.
This courtroom exchange wastes absolutely no time, and neither should you, because what you're about to witness is a case that spirals from a routine hearing into a high-stakes legal situation with life-altering consequences. At the center of it all is a defendant facing a habitual felon enhancement, which is one of the most serious sentencing escalations in the criminal justice system. We're talking about a potential minimum of 25 years to life. Not for a single act, but because of a pattern of prior convictions that now amplify everything. But here's where things take a sharp turn. What initially looks like a procedural hearing suddenly shifts when a drug test result enters the picture. And not just any result, a positive test for marijuana, which in many places might seem minor, but in this courtroom, it becomes a decisive factor that changes everything. Now here's the tension. The defendant claims he hasn't used anything, and even has a medical marijuana card. So the big question becomes, does that matter here? Or is the court operating under a completely different standard? Watch closely, because this judge makes one thing very clear. In this courtroom, science, rules, and strict enforcement override personal claims. And what follows is a powerful example of how quickly freedom can be taken away, not by a conviction, but by violating bond conditions. So ask yourself this as we go forward. Is the system being fair and consistent, or overly rigid in a situation that might have nuance? You're charged with unlawful possession of a firearm by a felon prior. This is just showing that you're an habitual felon, which means you're looking at a minimum of 25 years in prison to life. You were habitual felons 2 convictions ago, 2018. So here we are, yes announcement. We can get about this if I don't catch up. It's fine. Yeah, we need a little more time to just work out. As we okay, I'll reset 4 weeks. Get resetting. Have a seat over here, please. Probation. How did put him in the penalty box in this arrest? You've tested positive for tetrahydrocannabinol marijuana. That is, it's a crime to know and buy and possess marijuana. That's in your system. It's going to affect your bonds. You have a $50,000 and a GPS device right now. Is that what I just, yeah? He's got a GPS device, right?
He's straight down on this. I don't get it.
It's fine.
Yeah. We need more time to just help look out, get it resolved.
Okay, I'll reset it. 4 weeks, get it resetting. Have a seat right over here, please. Probation.
Yes. Not on the highlighted X1, please.
Let's put him in the penalty box. Thank you. He's got drugs in this arrest. You've tested positive for tetrahydrocannabinol marijuana. That is, it's a crime to imbibe and possess marijuana. It's in your system. It's going to affect your bond. You have a $50,000 bond and a GPS device right now. Is that right?
Yes.
Is that what I just?
Yes.
Right here is where everything begins to shift, and it's critical to understand why. The judge isn't just reacting casually to a drug test. This is directly tied to bond conditions. When someone is out on bond, they're essentially being trusted by the court to follow strict rules. One of the most common conditions? Staying completely drug-free. Now, the moment that test comes back positive, the court sees it as a violation of trust. It doesn't matter, at least at this stage, whether the substance was used recreationally or medically. The presence alone is enough to trigger consequences. And notice how quickly the tone changes. What started as a scheduling discussion instantly turns into a bond reconsideration hearing. This is a kind of moment that defendants, and honestly many viewers, don't always anticipate. So let me ask you, should a single positive test carry this much weight, especially if the defendant claims legal medical use? Or is the court justified in enforcing a zero-tolerance policy? And all right, you've tested positive. Your $50,000 bond is revoked. You are now $100,000. Plus, you must have a drug couch at all times, as a condition of your body.
Current. No, that's current.
All right. Yeah, he's got a GPS device, right?
Right, yeah.
And, all right. Well, you've tested positive. It's a $50,000 bond. It is revoked. You are now $100,000. Plus, you must have a drug couch at all times as a condition of your bond.
Your Honor, I know he says not THC. He says he hasn't used any products, but he does have a medical marijuana card. And he hasn't used any, but he has a card that allows him to do that medically. I mean, I know the court has a different feeling on that.
I do.
I understand that, but I'm just saying that this is something that there's a medical.
I'm sorry. Your bond's revoked, period. It's the way it is. Drugs on my watch and not allowed.
I haven't smoked marijuana.
I don't care. They all say that. It's in your system, sir. Everybody says that. And don't you think if somebody would just say, I've never done this, can I go home now? It would be pretty simple. But that's not the way it works. We test. If it's in your system, shame on you. And I didn't grant it. I don't allow it. And that's the way it is. Y'all got to figure that out. His bond is revoked. And is it set for, we said this for trial, right?
No, not yet, Your Honor. No.
Figure out what we're going to do.
We had a reset for 4 weeks for announcement, Judge.
Okay.
You're greater than that.
You're taken into custody. Period. That's the way it is. Robert Chason, come on out.
Excuse me, Your Honor. Can I retest?
I'm sorry.
I promise.
Sir, everybody says that, but the tests are scientific and I rely on the scientific tests.
Yes, sir. I have a marijuana card, but I still haven't smoked. I haven't smoked.
Sir, you've tested positive for marijuana. I'm going to rely on the science.
Well, back there.
I'm going to rely on science. Sorry. But your lawyer's going to talk to you. There's some things we might be.
This is a major escalation, and it happens fast. The judge doesn't just warn the defendant or issue a minor penalty. Instead, the bond is revoked and immediately doubled, jumping from $50,000 to $100,000. That's a massive financial barrier, and for many people, it effectively means instant incarceration. But it doesn't stop there. The addition of a drug patch requirement means a defendant will now be under continuous monitoring. This isn't just about punishment. It's about control and compliance moving forward. What's fascinating here is how the court uses layered consequences. Financial pressure, physical monitoring, and a looming threat of even harsher penalties if violations continue. This raises a bigger question about the system. Is this approach designed to correct behavior, or to ensure that any mistake leads straight back to jail? So, Your Honor, I know he says he hasn't used any products, but he does have a medical marijuana card, and he hasn't used any, but he has a card that allows him to do that medically. I mean, I know the court has a different feeling on that. I do. I understand that, but I'm just saying this is something that they're not. I'm sorry. You're your both, period. It's the way it is. Drugs on my watch and not allowed.
You were charged in this indictment with the second-degree felony of assault on a peace officer. And that carries with it no less than no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you are facing here, sir?
Yes, sir.
All right. This is an announcement.
Your Honor, we've gone over this case, talked to my client.
As that works. This is an announcement.
Your Honor, we've gone over this case, talked to my client.
How's that working?
Yeah, that's working fine.
Okay.
But my client is not does not want to take the offer, so
Trial.
There for trial.
It's set for trial, and just have a seat right over there before you leave. Get a resetting person.
You get right there.
And then, hey, hold on. There was 2 cases.
Yes, 2 cases.
Yes.
Mr. Chason, we're not through. Sorry. You had another. charge here in 25 CR 1806.
This is one of the most revealing moments in the entire exchange. The defense tries to introduce a key detail. The defendant has a medical marijuana card in many jurisdictions that could potentially change the conversation entirely. It introduces the idea of legal, authorized use, but the judge shuts it down immediately. Why? Because courtroom authority, especially at the state or local level, can operate under stricter rules and broader laws or medical allowances. In this courtroom, the judge is making it crystal clear, not on my watch. This is less about legality in a general sense and more about judicial discretion and courtroom policy. And here's the tension. The defense is arguing legality. The judge is enforcing compliance. So now you've got to ask yourself, should individual judges have this much discretion to override medical allowances? Or is this exactly what maintaining courtroom order requires? I haven't smoked in all. I don't care. They all say that. It's in your system, sir. Everybody says that. Wouldn't you think if somebody would just say this, I've never done this. Can I go down? It would be pretty simple. But that's not the way it works. We test. If it's in your system, shame on you. And I didn't grant it. I don't allow it. And that's the way it is. Y'all got to figure that out. His bond is revoked. And is this set for, we said this for trial, right? No, not yet. Figure out what we're going to do. We said we had a reset for 4 weeks. Right now he's not a judge. Okay, you're taken into custody. That's the way it is.
You're charged with harassment of a public servant, which carries with it, it's a third-degree felony, so that is no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. What we will do is, let me see the previous file, please. Let's start that you don't. That's a player. It's the same event.
Yes, sir. Part of the same incident.
I'm sorry, did you say, yes, no? Those are the words, hidden in the dictionary. What state want to do on this? Try them both at the same time? Or?
I don't know what I want to do on that at this stage, Judge.
Okay.
Likely I will try the assault first.
Okay. Well, it's second-degree felony. So you were looking at up to 30 years in prison for both of these. Do you understand?
Yes, sir.
Okay, you got a resetting? Have a seat over there.
I don't think he's on.
Not yet. Yeah, judge called back fluid.
Designing Matherson?
That's a defendant. It's not going to be available.
Does he have files?
This moment is all about credibility versus evidence. The defendant insists he hasn't smoked, but the judge isn't entertaining that argument at all. Why? Because in the courtroom, subjective claims rarely outweigh objective data. The judge leans heavily on one principle: scientific testing doesn't lie. Or at least, that's the assumption being made here. What's also interesting is the judge's tone. There's a clear sense of frustration, almost as if this is a scenario they've seen countless times before. Statements like "they all say that" suggest a pattern, one where defendants deny usage despite positive results. But here's where it gets complicated. Drug tests can detect substances long after use. So theoretically, someone could test positive without recent consumption. So the real question becomes, is the system accounting for nuance? Or is it operating on strict black and white enforcement where context doesn't matter? Robert Chason, you're honest. Sir, everybody says that, but the tests are scientific, and I rely on the scientific tests. Yes, sir, I have a marijuana, but I still haven't smoked. Clear as throat. Sir, you've tested positive for marijuana. I'm going to rely on the science. What about I'm going to rely on science? Sorry, but your lawyer's going to talk to you. There are some things we might be able to do.
No.
It's nothing.
No.
And Mr. Chason, you are positive for marijuana as well.
Yes, sir. I just recently quit 2 weeks ago. I should be quitting. I did.
Your bond is $20,000 on each case, 2 cases. They're doubled to to $40,000 on each case. The bond to revoke, they're double. Plus, you must have a drug patch at all times. And next time, if you can post this, it'll double after that when I test for you. But you don't come to court on drugs, period, in the ballgame. I'll give you, you get a copy of this.
Yeah, I think on the,
What are we doing on him next?
we originally set it for trial docket.
Oh, it's set for trial, and he can sit down and drop in jail waiting. That's the goal.
Or I'm Steinberger in your Billy Martin, I want to fire you and we'll see you about that.
This courtroom session is a powerful example of how quickly legal situations can escalate and how unforgiving the system can be when it comes to compliance. What started as a routine proceeding turned into a cascade of consequences: bond revocation, double financial penalties, added monitoring conditions, and the reinforcement of serious felony charges. The judge made one thing absolutely clear throughout. Rules are rules, and in this courtroom, there is zero tolerance for violations, especially when it comes to drugs. Whether or not the defendant believed they were acting within their rights didn't matter. The court relied on scientific evidence, prior history, and strict policy enforcement. At the same time, this case raises important questions about fairness, discretion, and how rigid the system should be, especially when medical claims and long-term detection factors come into play. Now we want to hear from you. Do you think the judge handled this correctly, or was this too harsh given the circumstances?